Hi, everyone. Thanks for joining today. Thanks for joining the webinar Planning for 2021 Legal Tax and Labor Considerations for the Construction Industry. My name is Alana Danowski. I'm the marketing coordinator for Withum's construction niche. Today's program will be presented by Ron Batista from Withum, Emmanuel Bondaris from Corwin and Corwin, and David Officer from David Officer Law. I just wanted to go through a few housekeeping notes before we begin our presentation. So materials for today's presentation can be found in the toolbar located at the right of your screen. Also at the bottom of the toolbar, you'll see a question box. All questions pertaining to the webinar content will be answered at the end. We'll do our best to address them. We will be emailing out a copy of the recording and also the slide deck after the presentation. And finally, once the webinar is over, there'll be a pop-up asking you to complete a survey. Please take a moment to complete it. It's our best way of being able to provide you with the best and most relevant programs possible. So with that, I'm going to hand it over to Ron Batista.
Thanks, Alana. I want to thank everyone for attending the webinar. My name is Ron Baptista, as Alana mentioned, and I'm a partner at Withum's Woburn, Massachusetts office. I'm also a member of Withum's construction niche for the New England market. Withum has dedicated construction team members who provide their focus on developing these type of webinars and trainings for our clients. And we thought that this would be a good time for us, with COVID, there still being significant uncertainty with COVID, to revisit some important issues facing legal matters and also tax and financial planning matters. So with that, I'm going to pass it over to Emmanuel and David to introduce themselves, and then Emmanuel will begin discussing some legal considerations.
Great, thanks, Ron. Hi. I'm Emmanuel Bondaris. I'm a partner at Corwin and Corwin. Our office is actually also located in Woburn. We have, for about 70 or so years now, represented contractors, subcontractors in a variety of construction claims and other matters. And it's a year like we've never seen before, all of us. So we thought it would be instructive to people to review certain core issues in planning and facilitating both contracts and collection matters in light of COVID and sort of the things that have grown out of that. So I'll be speaking on those issues today, hopefully giving people a sense of what they can do both upfront to avoid problems and failing that, how to proceed on the back end to put yourself in the best possible light. David?
Good afternoon. My name is David Officer. I'm a sole practitioner at David J. Officer Law, PC. My practice is general litigation in state and federal courts. That includes labor matters, employment matters, and construction matters. I've got 30 years experience in labor and employment as well. Today, we'll talk about a few of the things that I think are important going forward for people to know about personal protective equipment, unemployment claims, and those kinds of things on the employment end of the construction business.
Okay, great. So let's start with some legal considerations. I tell people all the time, an ounce of prevention is, much better than a pound of cure, or maybe even 100 pounds of cure. Anything that you can do on the front end to protect yourself is infinitely better than trying to scramble on the back end, or even if you're not scrambling, just trying to deal on the back end with problems as they arise. It's bad news, obviously, that we're still talking about COVID. I did one of these seminars 6 or 7 months ago, and if anyone had told me I'd be doing another one in 7 months' time, I'd have been very depressed. But here we are. But the good news, okay, is that we have seen some of the things that have arisen as a result of that, and now we can change our behavior in order to put ourselves in the best possible position. So, negotiating upfront for favorable contract provisions is one of the things I want to focus the most on, and we'll see some of those specific things. But, selecting your projects carefully, selecting the people that you work with and for carefully, pricing the job with some understanding of things that may or may not arise as a result of COVID, those are all key. And of course, no lawyer can tell you how to do that. That is, your own experience dealing with people, your interpersonal relationships, your sense of how to estimate a project to protect yourself as best you can, but still get the job. It's a balance, of course it is, right? But all those things are critical. So, sit down and think about what are the things that we're seeing. And from my experience with clients, and I'll tell you the good news is we're not seeing a ton of claims, which is wonderful. But problems that we have seen are long lead times for materials, workers getting sick and not being able to come in, and then people that they work with within the same core team having to quarantine, workers being forcibly, although briefly, pulled off the job by their unions, delay claims, right? Both the need for additional time and also the need for additional money. Jobs getting shut down. That hasn't happened, I know, in a long time, but it did. And, given our governor and the mayor of Boston, theoretically it could happen again. And cash flow problems, particularly in industries, that are hit hard, so restaurants and that sort of thing. So, again, planning for that economically and also relationship-wise is key. All of these things are general advice as well as COVID-specific advice, right? So knowing your rights before you start a job in terms of claims, how to secure yourself with liens and all that is pivotal, and it's more important now than it was. It's always been. And then following the procedures necessary to preserve and exercise those rights. So let's take a look at some specifics. If we could go to the next slide. Yeah, okay. So here's some favorable provisions that we've put into contract riders. And my firm, as some of you may know, specializes very much in subcontractor claims and dealing with issues for subcontractors. But I do think that these things can broadly be applied both up and down the food chain. So we've looked at ways of protecting our clients before a job starts, once you've selected a job, right? And here's some provisions. Okay, so this first one is very COVID-19 specific, and it's a bit of a force majeure type clause, and we'll talk a bit about those, but let's take a look. It says, in the event of a COVID-19 related suspension, shutdown, work stoppage, labor walk-off, or other delay or impact of any kind, subcontractor shall not be deemed in default, shall receive an extension of time, shall receive a cost increase, and that includes material costs, demob, remob, and other costs arising from COVID-19 related event. And I asked the clients that I've proposed this language to, has this been accepted? And they've said it has. I mean, obviously, look, nothing is universal, and you don't ask, you don't get. And there has been some success in securing provisions like this. The second one is similar. It says the parties agree COVID-19 related cost increases arising after execution, okay? So things we couldn't have anticipated. And here are some things we've literally seen, right? Parking charges that we have to cover because workers can no longer carpool. They're forced to park in downtown Boston in separate cars. Things like that are not included in the price because how could they have been? No one saw them coming. And we'll get a change order for that, okay? So taken together, those two things cover a whole lot of ground, and if you can get those or even dial back versions of those, you're going to be much better off, right? Now, the next three don't specifically reference COVID-19, but they are protective of your rights in a COVID-19 related event. So let's take a look, okay? In the event of a convenience termination, and what is a convenience termination? That's a termination of your contract for nothing that you've done wrong. Okay, it's not a default termination. It's just a termination because the job has been shut down or for some other reason. Usually, it's a top-down event. Okay, and what happens? Well, subcontractor in this case, but contractor too, right, shall be paid for all work performed up to the date of termination, plus reasonable costs incurred for that termination. Good, right? I mean, define your rights. Contractors, if you're a subcontractor, this is very important as well. Contractors' receipt of payment from owner shall not be a condition preceding to payment to sub unless the owner is withholding due to your fault. Now, I would recommend trying to get a provision like this in a rider no matter what. But convenience terminations, which typically you think it's kind of rare, less rare. Still not likely, but more apt to happen in light of COVID-19, puts a little bit more emphasis and importance on a provision like that. We move on to the next one. Again, it has a general application, but subcontractor is a union union shop, right? Can't be held liable or deemed in breach for a strike, a picket, a walk-off. Okay, now that's happened, or a like cessation of work by its employees. Now we've been proposing language like that forever, but last spring we saw people walking off jobs, being pulled literally forcibly off jobs for some period of time. Know your rights. Wouldn't it be great if we had a provision that said if that happens to us, it's not our fault, we're not deemed in breach, And the last one, failure to provide timely notice shall only be a defense to a claim to the extent the contractor is prejudiced thereby. Now, why would we like that? Well, most subcontracts, and you've seen them, right? They're 40 to 1 million pages long, and they have a lot of provisions in there that are designed to deprive you of your rights to assert a claim in the event that you don't give a prescribed form of written notice in a particular way. Usually it's either in hand or by certified mail or something very cumbersome like this, within a short period of time after the event arises. Well, COVID has made that hard, right? We need to give notice, okay, we understand that, but oftentimes people are scrambling, or were scrambling, at least back in March and April, to try to figure out, how do I give this notice? I don't know what the impact of this thing is. I only know that it's bad, okay? And timing can be an issue as well. So we put in something like this. So these are 5 examples of the types, and there are more, right, of provisions that you can use up front. So if a COVID-19 event happens, one, the subcontract speaks to it, and you're not left wondering what to do, but also it speaks to it in a way that's more favorable if you're a sub to you, and these could be modified for use in a prime contract, right? Giving you rights that you otherwise may not have, okay? So if we could go to the next. And these will be made available after the seminar, by the way, so I know it's impossible to retain all of this, I'm sure. But what happens if, despite our best efforts, we've tried to get favorable terms, but if you want the job, we're not agreeing to any of that, you get back. And so you take the job anyway, right? And you're going to go with it. And hopefully you're working with good people and that sort of thing, but something happens, okay? At least you'll have reviewed, right, the contract provisions before problems arise, and you'll know what they are. And so here are a couple of provisions that actually are very typical, but in COVID-19 times, very harmful, right? More harmful than you would expect. The first one is just a standard sort of no damages for delay provision that says, in essence, that if you have a delay or a hindrance, an impact, an interference, an obstruction, right? Anything of the sort, okay? All you're going to get is a time extension, and you're not going to get any money for that. And you're only going to get the time extension if you give that written notice, there it is again, within 5 days of the commencement of the delay, right? Okay, so that's a provision that you're going to want to know about. You don't want to be reading the contract 1 week after the COVID-19 related suspension occurs and sending the notice out. Then you're handing somebody a procedural defense, right? The second provision is actually the third paragraph here. It's a sort of provision that you would read it, you'd gloss over it, you'd say, yeah, I agree to that, of course I do, and it's fairly typical. It's the idea that time is of the essence under the subcontract, and you're going to work diligently and continuously to get that work done by the completion date. Now, yeah, I mean, of course, no one's going to say no to that. I understand that, right? But if you think about it, if you haven't done anything to protect yourself with some of those prior provisions that we looked at, something like this is now something that is going to be used as a weapon against you potentially, right? Because your failure to prosecute the job, even under bizarre circumstances, like the union came and told all your workers they can't work anymore, somebody could argue that you've breached this provision and it's a material breach, right? So you see now the importance, of course, of negotiating on the front end, and you see how clauses that typically, you gloss over them perhaps, but they could really, really harm you. So let's go to the next slide. So what do we do, right? I mean, we have these provisions, we didn't think of much of them, and now we have a problem, okay? The advice there in very general terms is give notice, Give notice early, give notice often, right? Like voting. Request a time extension, request a price increase, perhaps even if you're not entitled to it, request it, right? You know, and why would you do that? Well, we want a record that we've done everything we can to get relief, okay? And that we've apprised everybody of the circumstances that we've been dealing with and what the issues are, and that we're not the cause of them, okay? Very important. And the second point is more of a note. In some jurisdictions, okay, even if you have a no damages for delay provision, the sort of thing that says you'll get time, but you won't get money, you know, and you may not get time. Well, those provisions don't always hold water, okay? So if you're unfairly denied a time extension, right, some judges will throw a no damages for delay provision out the window. So that's why I say request that time extension if you have any inkling that you need it. This is, by the way, general advice. This is not just COVID-19 specific, although it certainly is COVID-19 related and important. But if you don't do that, you've taken an argument that you might have to your entitlement for money and thrown it out the window, right? So give that notice. And last but not least, we're going to look for other contract provisions, even if we didn't get the ones we wanted up front with a rider, that might help us in some way, right? And so let's see what some things, actually, let's take a look first at the next slide, which is a notice, a sample notice. And I won't take pride of authorship for this. This was actually sent out by a client, but it's wonderful. And it's a good example of the kind of a notice, first of all, that documents everything that's happened and why there's a problem and how we're not responsible, says that we're doing all we can to comply with the contract, both in terms of doing our work, but also in terms of putting in a claim, right, as best we can at this point, and then builds on the relationship at the end by saying we're all in this together, okay? So briefly, I won't read the whole thing, but the first paragraph talks about the circumstances, the emergency circumstances that have brought us here. And of course, everybody's aware of them, but if there's a lawsuit 5 years down the road, right, you know, people aren't going to remember. So documenting something like that is wonderful, okay? Second paragraph builds on that, says, look, the job site has been shut down. We have nothing to do with that. We expect this is going to cause the following harms, okay? And we're going to need time. We're going to need money. And here are the different categories of harm that we're suffering that we may need to pass through to you as best as we can determine right now. So there's material increases, material cost increases, material storage costs. We're going to have to remobilize and so forth, right? Putting it all on the table as best as we can. And the second thing, you know, sort of builds, the second half of this, builds on that and says, we're doing what we can to get all that information and we're going to give it to you. So if you have a contract provision that requires you to give notice within 5 days of the event coming up, and you say, it's literally impossible for me to do that, I don't know what's going to happen in the future, something like this is a great way of addressing that. You know, you put the person on notice, you told them that you can't quantify these things yet, but you are doing it and you will supplement, right? And then finally, there's just this sort of warm, you know, I'm going to keep giving you updates. We're here with you now more than ever, right, to get through these difficult times and so forth. And what we found in March and April and May and all that is that people really were working together cooperatively, right? That you would have expected potentially a lot of claims. And there was seemingly, you know, a much more than typical broad understanding of we need to do something about this, you know? And so a tone like this is appropriate, much more appropriate than, you know, something that reads like a demand letter. So if we could just move on. Okay, so we talked about notice, and then we've talked about other contract provisions potentially that might help you, right? Okay, we opened with an example of a very COVID-19 specific rider provision that was akin to what we call a force majeure clause, right? It's the idea that something has happened, it's nobody's fault, it's absolutely incredibly unpredictable, and here we are, so we need relief, right? And that's in essence what a force majeure clause is, okay? So even if you don't have in your rider a COVID-19 specific one, maybe you have something like this. A subcontractor It's going to start work. Okay. You're going to carry the job forward, right? Unless you are detained by what? Other subcontractors or unforeseen or unforeseeable events like adverse weather, acts of God, strikes, walkouts, right? Things like this. Now, this says nothing about COVID-19. In a way, I'd rather have, in addition to this, something that actually addresses it, right? Or perhaps I could amend something like this to build COVID-19 right into it and put it in the laundry list. And that's, more palatable probably to somebody reviewing potential changes to a subcontract than a whole new provision, right? But some modification like that. But if I haven't got those things, this still gives me something, right? Because now I can say, hey, a pandemic is an act of God, or it's certainly an unforeseen event. It's something that I have no control over. And so I need some form of relief. And here it gives you additional time. And we've talked about how to address that to some degree. We're still going to ask for money, but at least we have something in our favor. Okay. And that's in effect what a force majeure clause is. They're more thought about now probably than any other time in a very long time. Okay. But let's say that's even missing, okay, or appears to be missing. Is there anything else that might help? Sure. If we could go to the next slide. A lot of contracts, even if they don't have something that specific, will have things that are akin to it. And perhaps the gold standard of sort of, boilerplate form contracts is AIA A201 general conditions, right? Force majeure doesn't appear. Those words aren't in there. But is the concept in there? And if I'm reviewing my contract, can I find something like it? Well, there's emergencies, okay? So it says in an emergency affecting the safety of persons or property, you're gonna try to prevent that and you'll get compensation or an extension of time. Well, that sounds good, right? I mean, perhaps a pandemic is that, Second provision says delays and extensions of time. If the contractor is delayed because of an unusual delay in deliveries, an unavoidable casualty, or some other cause beyond the contractor's control, then time shall be extended. And that same section, 8.3, a little further down says, by the way, this isn't intended to bar you from seeking money. That's all good news, right? So reading the entire thing, because I might not know that a force majeure clause isn't going to have its own section and its own heading. I mean, I might be looking for that if I'm reading quickly, but if I read other things, geez, maybe I have those same rights. And so again, forewarned is forearmed, right? So if your contract has 50 pages of 8-point font, it really is beneficial to take a look at all of it and say, is there any language in here that will help me in some fashion, even if it's half a loaf, right? And here are some places that could hide. I mean, delays. You wouldn't really necessarily look there for a force majeure kind of argument, but it's there, right? So reading the entire thing is obviously a benefit. We could just move on. Okay. If everything else fails, I haven't got a good provision. I have a terrible job. I'm working with people who are trying to put the screws to me. It's not impossible, even then, that some court-made exception will help you, okay? And, I always say, by the time you get to a lawsuit, to a degree, you've lost something, right? Because you're now spending money on legal fees and so forth. So, but there are a series of doctrines, and we won't, dwell on them too much, that apply and that a court can use to help you, right? Impossibility, impracticality, right? This is the idea that if you can't perform for some reason, the government has shut down the job, well, I'm not being asked to do anything illegal, right? My performance should be excused, not a breach. The doctrine of frustration of purpose, very similar, okay? I was hired to build something, the government shut it down, I can't build that thing, it's not a breach. And illegal performance, these are all, obviously the same kind of idea, okay? So, don't despair necessarily if you haven't, got a contract provision that will help you. There's still hope. But like anything else, you don't want that hope to come in the form of a judicial decision 3 years from now. You want to be able to actually point to things and maybe convince somebody. And I'll tell you, a contract provision that you can put into a letter and point to is much, much better than sending somebody 17 case sites that say, someday a judge will say that this was impractical, right? It's not very compelling. Okay, if we could just move on. Okay. So how then, we've planned, we've done our best, we find ourselves in a situation where the money has stopped, through no fault of our own. It's all COVID-19 related. What are we going to do? Very simple. Again, notice provisions, we're going to find out what those are. Claims and disputes provision, we're going to read those. We have already read them, right, before the claim even arose, and we're going to do that thing, okay? And maybe it'll look like the form we saw a few slides back, but we're going to absolutely give notice. Even before the job starts, we're going to get a copy of a payment bond if there is one. On public construction projects in Massachusetts, there's always one, right? And on private jobs, there may be. And so we're going to find out. We're going to have one in the file, okay? It's a relatively, especially on public jobs, it's inoffensive and a fairly easy thing to get. And on private jobs, it should be too. We're going to ask for it, and we're going to get it, okay? And so, by the by, especially on private jobs, always, the bond is in itself a form of contract. And it can have, like a contract, notice provisions and other sorts of provisions to document your claim that you should, and time provisions that you should be aware of, again, before the claim arises. Particularly, in Massachusetts, on public jobs, we take the position that really the only requirement is that you file suit within 1 year of the last date of supplying labor and materials included in your claim, okay. But on a private job, that rule doesn't necessarily help. So on a private job, we absolutely are going to read the bond, and we're absolutely going to comply with the bond's terms so that we don't face a procedural argument from a surety. This is especially important if, we could be facing a GC that goes into bankruptcy or something like that, right? And we need to be able to secure ourselves, okay? Similarly, lien requirements, very important. Whatever state you're in, to have a sense of what the timing of those lien requirements is. And please, I know I'm a lawyer, I know this sounds like marketing, but do not go to one of those services that will, give you a lien for $4. They botch it a lot. Okay, it's not the most expensive thing that we do, and it's money well spent. It really is. Rather than finding out later that your lien is invalid, we've seen a number of those. And so is it self-interested? Yes, to a degree, but it's also, I think, very solid and good advice. And also, if you find that you're a subcontractor on the project, you may have additional notice requirements that you have to meet to either protect yourself at all or to enhance your position as a claimant, okay? So you've just got to know those, going into it. And last but not least, don't be shy. Obviously, yes, we're all, trying to maintain good relationships to get future bid invitations and all that. I know, and I know it's a bit of a balance, right? But, again, more than previously, asserting your rights in a way that I think people will understand. If you explain to them that I'm just trying to protect myself, give whatever notices you have to give. If you have to report a notice of contract on a project to assert a mechanic's lien, do that thing, and just tell whoever you're working with or for up front, I'm doing it really because, blame it on me, right? Blame it on your lawyer to protect myself. It's not a declaration of war. It doesn't mean we're going to have a bad project. I just need to be sure that I'm going to be okay, because the last thing you want is to find that you're not. And don't take advice from other parties that don't have your best interest at heart. Surety claim representatives are sometimes a good example of this on what your rights are and how to enforce them, particularly when it comes to holding off on asserting a claim. It wouldn't be the first time someone has done that, waited until the bond deadline has expired, and then found the surety is saying no way. So I hope that was useful. Again, this slideshow will be available afterwards, but in a nutshell, know your rights, don't be afraid to assert them. Thanks.
David, you're up.
David? I don't think he can hear.
David, you have to unmute yourself.
Ah,
Yep, you're good to go. David, you just muted yourself again. You have to unmute yourself.
Alana, do you want to move on to the next?
No, I'm sorry. It took me forever to get that unmuted. Thank you. Emmanuel, that was good stuff. Folks, I've worked with Emmanuel for 30 years. He and the people in this firm are really smart. So pay attention to what he tells you and help give him a call. I'm going to be very brief and talk a little bit about unemployment and about personal protective equipment and job sites from a labor perspective. Don't be frightened by this first slide. This is just a general proposition that all of you know. Yes, employees can always refuse to return to work, right? Employees can always say, I don't want to come to work today. I'm sure everyone has had employees like that. So the question isn't really, can they refuse to come to work? The question is, what can be done about it and what are the parties' respective rights? Next slide, please. Can employees who refuse to work because they're afraid they'll contract coronavirus collect unemployment? The answer is generally no. In order to collect unemployment, at least in Massachusetts, employees must show that their fear was reasonable in the circumstances. In most cases, they would have to prove something more than the normal general fear of contracting coronavirus. Now, on top of that, or aside that, an employer is obliged to keep a workplace that is reasonably safe. And we'll talk about this in a minute, but for that proposition, I think the best place to look is to Centers for Disease Control guidelines and guidelines from the state and municipality in which you're working or where the project is located. Next slide, please. So as a side to that, what I want to talk about also, besides employees refusing to work, is are employees allowed for leave or to leave to care for sick family members? The answer is yes. Generally, if someone has in their family has a coronavirus illness, employees are entitled under the Family and Medical Leave Act to take 12 weeks off. There's nothing new or unusual about that. Next slide. However, more employers are now covered under the FMLA, under emergency provisions for the coronavirus fastback at the outset. And there's an expanded FMLA eligibility under the Families First Coronavirus Response Act. Through December 31st of this year, remember, FMLA was applicable to only companies with more than 50 employees. Now, FMLA is generally applicable to any company that has fewer than 500 employees. So any company with fewer than 500 employees must provide leave to employees who have coronavirus, employees who are caring for a family member who has coronavirus, and employees caring for a school-age child whose school has been closed. I haven't done a thorough drill down as to what if the child is going to school that's hybrid, and some days they're there, and some days they're in school, some days they're from home. Presumably they would be entitled to intermittent leave to cover the days when the child is not in school. So that's generally the response to the question about FMLA. Next slide, please. Let's talk briefly about personal protective equipment. The question for most employers is, what must I provide for my employees? And again, the best answer is, in case this is a moving target, is check state and local regulations and the Centers for Disease Control guidelines. I will tell you that most regulations, for instance, the Massachusetts regulations for construction sites, are aimed at workplace sanitation and workplace conduct, not protective equipment for the individual employee. Next slide. For example, in Massachusetts, under guidelines that were issued in March and that are still in effect for construction sites, there's zero tolerance for sick employees. If an employee has fever, cough, shortness of breath, or sore throat, they're sent home. And each employee is required to self-certify at each shift that they don't have a fever, they don't have symptoms, the questions you get asked when you go places. The third is, if you're inside a closed building envelope, they'll be temperature screened to assure that they don't have symptoms of the coronavirus. Now, the rules also require that an employer must maintain social distancing where possible. As I explained, these regulations rely less on personal protective equipment and more on management. So to the extent that employees, it is possible, employers need to think ahead and contemplate what tasks are going to be done at a work site, and assure that to the maximum extent possible, there's social distancing. Now, if social distancing isn't possible, you need to think about personal protective equipment. And we'll talk about that in a moment. Another part of the regulations is that employers must provide more sanitary conditions. They have to have toilet facilities and provide opportunities for hand washing and sanitizing. They have to keep a clean workplace that's sanitized. If you're on a project, that's going to take a lot of coordination and cooperation, mostly with the general contractor, I would think, more than anybody else. But if you're one of the earlier subcontractors on a job, you may need to take on more of that responsibility than you might if you're in the middle of the project, where you've got a general contractor and he or she knows that there are going to be a lot of subcontractors on the site. Next slide, please. For personal protective equipment, understand that cloth face coverings are not generally PPE, personal protective equipment, under OSHA regulations. OSHA's been very careful to point that out, and I think their point is, don't think a face covering substitutes for respiratory equipment where respiratory equipment is required. So what they want to make sure is that no one thinks, oh, a face covering is enough to cover all respiratory issues. No, if the regulations require more sophisticated respiratory equipment, then you must provide that. The general duty clause under OSHA may create an obligation for employers to provide face masks in some circumstances. And you'll see further on that some of the advice is, the best practices that I recommend are that you have face coverings available for your employees. Unless OSHA otherwise requires it, it doesn't have to be an N95. It has to be a cloth face covering or the kind that you see people wearing in the grocery store. Nothing more than that. But as you'll see, I think it's a best practice for an employer to have it. Now, a respiratory hazard involving coronavirus might be if you've got employees who are in close contact with someone who's suspected of or confirmed to have COVID-19. This begs the question, if they're suspected or confirmed, why are they on your job site? But if they are, then you may have to be providing respiratory equipment for your employees. If you've got someone who's suspected or confirmed to have COVID-19, I think the issue needs to be why they are there rather than worrying about the respiratory standards. But if you have an employee who's going to be working side by side, you've got to make sure you've got the respiratory protection standard equipment. OSHA recommends having replacement face coverings for employees when their face coverings become wet or soiled. So that is one OSHA-driven reason why you should have face coverings available on the job for your employees. Next slide, please. The bottom line here is that the best practice is to have face coverings. The CDC general business guidelines now, well, for the past several months have said people should be wearing face coverings. The message has been driven by the CDC that that's important, and it's important to the extent you're in a business, you need to comply with it. So there's no law, generally speaking, that says an employer must provide the face coverings, but you are far better off having face coverings available in case an employee forgets theirs, loses theirs, soils it, or gets it wet. You won't have to say, all right, well, go home from the job and get another face mask. Next slide. The question arises, can an employer require employees to wear face masks? The answer is yes. Because it's CDC guidance and under state law, as required, as promulgated at the beginning of the outbreak for construction sites, employees can require employees to wear a face mask. Along with that, an employer can discipline employees for failing or refusing to wear a face mask if the situation is such that the CDC guidance suggests a mask. Next slide. The current guidance from the CDC is that you must wear face coverings in public settings where other social distancing measures are difficult to maintain, especially in areas where there is significant community-based transmission of COVID-19. I think that's true for most of the United States now, that there's significant community-based transmission. Now, you might be able to not require face masks if people are on, distant sides of a construction project. But my advice, and I think the current advice for everyone, is enforce wearing face masks. If for no other reason than people become used to them, and you don't have to worry about whether they need to wear one when they're standing here or when they're standing there. It's just a uniform guideline for your company on the work site, and I think that makes it easier to enforce. Next slide. What should employers watch out for? There are exceptions to wearing face masks. I don't think it'll come as a surprise to anyone that employees may assert that they can't wear a mask on religious grounds. If that happens, you must engage in a conversation to discuss possible accommodations. You have to know what the religious requirement is, not what the religion is, what they say their religious requirement is, and how you can best accommodate it. My further advice is if you get an employee who tells you he or she can't wear a mask on religious grounds, that ought to be a trigger to you to call a lawyer. That's just the law there is rapidly changing, and you want to be able to get the best advice you can, because that road lies ruined if you don't properly address the religious issues of one of your employees. Similarly, if an employee alleges a respiratory illness or other medical reason that prevents them from wearing a mask, again, you must engage in discussion with them, because you may have an accommodation obligation under the Americans with Disabilities Act. Again, either turn to your Human Resources Department or call an attorney if someone tells you they can't wear a mask for medical reasons. Finally, if you have unionized employees, unions aren't going to be bashful about reminding you or telling you you need to bargain with them on the impact, perhaps. But you should engage in a discussion with the union before implementing any new rules. I think that's it. Think carefully about face masks and coverings. Do your best to accommodate the needs of your employees. And if everyone works together, and I think that's happening mostly, I haven't had that many calls from employers telling me they're having trouble with people not wearing face masks or flaunting the rules. Everyone can work and projects can go on. Thank you.
Thank you, David. Thank you, Emmanuel. I'm sure most people on the call have probably had some sort of PPP loan given to them over the past 6 or 7 months. One of the most important things probably facing companies this year is going to be how those proceeds are forgiven and how that's going to affect your tax return for 2020. So in order to start off in talking about tax impact and things to think about for 2020, understanding how the payroll protection program loans are going to impact your tax return may be the most important thing. The CARES Act originally allowed for proceeds to be forgiven, and a lot of people initially interpreted that as being, tax-free. However, the IRS on April 30th issued a notice stating that, even if those proceeds are considered tax-free, there's a clause in the IRS that says if you use proceeds that are not taxable, then you can't deduct the expenses that you paid with those proceeds. So as many people are going through filing their forgiveness for this loan over the next few weeks or few months, it's important to also know that that's not necessarily going to mean that you're not going to have to pay taxes. There's been some activity in Congress that's brought this up, as it wasn't really their intent to allow for this to be taxed, or these expenses to be not deducted. But until maybe at some point we'll have a president in the next couple of weeks, and we'll see what happens by the end of the year if anything can get put into place. But as of right now, it's important to know how this is going to affect you under the current law. Next slide, Alana. So what the impact that it will have is any payments that you made to your employees, landlords, the utility companies, the types of expenses that were identified in the PPP loan as acceptable uses, that's going to be added back to your taxable income. And so it's going to be important to understand what that's going to do to your taxes, because even though you may be thinking about your financial statements at this point in time and what your net income is, if you had a PPP loan of $1 million and you use that all for your employees, you're most likely going to get $1 million disallowed deduction on your 2020 tax return. And that could have a substantial impact on what your tax liability is, whether you're a corporation or a pass-through entity. So it's going to be important to know what your corporate taxes will be, and also how that's going to pass through to you individually, and what your taxes will be at that when you file your individual tax return. Next, Svetlana. Other important tax considerations. This is the time of year where you should be thinking about purchasing equipment. As many of you probably know, each of the year when you meet with your accountants, you're able to take what's called 179 expense, which can allow you to depreciate the full cost of equipment up to $1 million, and also bonus depreciation. So this is the time of year to identify what types of equipment you need and bring that into place so you can start to purchase those assets and get them in service by December 31st, 2020. It's always good to buy things you need. You may not want to keep buying equipment that you don't need just to get the tax deduction. So that's why I emphasize if you need the equipment. Also, COVID it's been a tough year for everyone, including your employees. And if you have any thoughts of giving year-end cash employee bonuses, this is the time to think about how much you're gonna give to them. Just a reminder, if you're a cash basis taxpayer, those bonuses have to be paid by December 31st, 2020, or the end of your fiscal year. If you're accrual basis taxpayer, then you have 2.5 months till the end of the year to actually make the payment to the employees. Next slide, Lana. Another thing you consider doing if you are a cash basis taxpayer, prepay expenses. If you know you have some significant expenses come due in January, it's a good idea to prepay those because you'll be able to take that deduction in the current year as opposed to waiting until 2021. Another thing I like to tell cash basis taxpayers is look at your billings and look at your collections and see how you stand, because as people may know who are cash basis taxpayers, if you collect on your receivables, that's when you're going to pay taxes on that money. So you're going to want to see what your net impact this year is on deferred receivables from 2019 and payments received in 2020. Similarly, with your vendors, you want to be able to see who do I have to pay by year end, and how is that going to affect when I look at who I didn't pay at the end of 2019, paid during 2020, and now have left to pay at the end of 2020, because you'll be able to fully deduct on your tax return payments to vendors, and then you'd have to pick up your collections that you received during the year from your customers. Next slide. Another key point this time, which I thought was a good idea to mention, is managing cash. We're unsure what's going to happen with COVID-19. We could be in a shutdown again in the winter like we were a year ago if numbers go in the trend in the direction they're in. We're uncertain about what's going to happen with the president, who's going to be the president, what tax changes are going to happen in the future. So it's a good idea to have some things to know about in sort of managing cash so you don't have any issues come 2021. First one, just to reiterate, is doing a year-end tax planning. That's going to give you everything you need to know about how the PPP loans are going to affect you, what benefit you're going to receive from the equipment purchases, and what your taxable income is going to be on a cash basis and an accrual basis. So you can then see how that's going to affect you personally, and you have an idea of how much cash you're going to owe come April 15th of 2021. And the key point is that you don't want to be surprised, especially if, in the first quarter of 2020, a lot of the Northeast construction companies are in a slower period. Cash is not best at that point in time. You don't want to be surprised knowing that you may owe tens or hundreds of thousands of dollars in the first quarter of 2021. Another key important point is to keep monitoring your receivables and collections. Change orders are important because if you get them approved and signed right away, then there's no claim, there's no argument that your customer can have that you aren't supposed to do that work. We always emphasize change orders as accountants and auditors because that's when you can begin to recognize that as part of your contract. But it's also important for you to identify with your customers what the change orders are going to be, how much it's going to be for, and get it properly signed and approved. So come 30, 60 days later, when an accounts receivable person is looking at it, or an accounts payable person at your customer is looking at the bill you sent them, they'll see that the change order was properly approved and they'll remit payment. If it's not there, then that's going to delay some time for you to catch up, get your change order in place. And if you hadn't had it signed at that point in time, you may get pushback from your customer because now people are just remembering things that were approved verbally. The other thing is have regular communication with your customers if they're greater than 60-day old balances. You don't want to let those linger. I know construction companies tend to have a longer leeway, depending if you're a subcontractor, even a general contractor. You usually get paid when those people get paid. But knowing who owes you money and constant communication with them and trying to get money in the door quicker and avoid them from going significantly past due. And that's what makes change orders important, because if you get to a point where some of these customers have to go to collections, you'll have all your change orders, your original contracts, all the signed information in one place. You can give it to your attorney, and then there'll be no question as to the amount of money that may be owed to you. Another thing, this is a good time to meet with banks again. I'm sure many people met with their banks earlier this year to see about credit line increases and may have received some. I know a lot of companies may have been pleasantly surprised at the results that they had during 2020 in the COVID crisis. And if they did have good results and have strong financial statements, it's good to meet with that bank once again. It's always easier to get money from a bank when you don't need it, because when your numbers are good, that's when the bank's going to approve increased lines. But when you desperately need money and your numbers are not so great, you're not going to get much success there. And it's also important this time to think about your debt covenant compliance. Some of the issues that you decide upon during tax planning may impact your gap-based financial statements that you're going to give to your bank. You want to make sure that you look at how those covenants are affected, so you don't fall out of compliance. So it's always good to know when you make these decisions and pay things like paying bonuses or buying more equipment, how is that going to impact your debt covenant on the projected amount of income you're going to have at year end. Next, Alana. Another thing to do is think about developing a cash flow projection. These can tend to can help you forecast cash over 3, even 12 months. It helps you to proactively manage your costs during this slower period. This is something that you could reach out to your accountant, think about creating something like that, so you'll be able to know what your cash looks like, what your future expenses look like ahead of time, and not always, at month end or at year end, when you get to see, you start to realize how much money you're spending in certain types of accounts, especially operating expenses. The other thing is to know, I know most people know what their backlog is, but it's really important to keep looking at your backlog on a monthly, weekly basis. The backlog is going to show how much work you have coming up in the future. And that's going to be important to know, how busy you're going to be in certain months, how much cash you may need in those months if things are not so slow, what your staffing requirements are going to be. So if you can go to the next slide, Alana. I included here a little backlog analytical example, which can help you measure, how strong your backlog might be at any point in time. So what this basically does is it takes your gross profit in your backlog and you divide that by your general and administrative expenses. A healthy ratio is 0.5 to 1. So just to further illustrate this with an example, if we assume that you have a backlog of $4 million and your average gross profit has typically been 20%, and your general administrative expenses average 1.5 million, we can go to the next slide and see how these numbers would work out. If we take your 4 million of backlog revenue and multiply it by a gross profit percentage, that's going to be what your gross profit in your backlog is. That's money that your backlog is forecasted to use to pay for general and administrative expenses. If we were to take that number and then divide that by 1.5 million, which is what we estimated to be your general and administrative expenses, that gives you a 0.53 ratio, which shows a healthy backlog. But it also means that if all things go and you're able to reach that 20% gross profit, you're able to keep your general and administrative expenses in check. You should have 6 months of operating expenses with work you already have signed today. So that helps give you an idea of how far out your backlog is to cover your current operating expenses. Next slide, Lana. Yeah, and just to finish, it's really important to be in contact with your accountant about many changes. As I mentioned, the election has still not been resolved yet. How that's going to affect people going forward, we're not entirely sure. If it's Biden, if it's Trump, what does that do to certain deductions that Trump implemented? Those are questions that we're not going to know by year end, but we're going to get more information as the next couple of months and even as we head into the first quarter of 2021. So it's important to, follow how that's going, keep track of what any future stimulus plans are going to happen. And once the election ends, maybe that's something they may take up once again. And if Congress acts on the PPP exclusion of deductible expenses, it's also worth mentioning that that's something that could also happen possibly in early 2021. So it might not be something they get to by the end of the year, but maybe it happens earlier in the year. So keep an eye out for that. We're in a constant state of flux, it seems, with this. And with COVID in the mix, we don't, with these uncertainties, knowing how your company's doing, knowing your tax position in a best case and worst case scenario is going to make you that much stronger once 2021 begins. And so now, questions. Alana, I don't see any questions. Am I missing them? Alana?
There is one question, Ron, I sent.
You sent it, I see it.
Yes.
So for time and material change orders performed during PPP expense period, what is the best practice for cost segregation assessment to minimize argument from owner that change order labor costs were not incurred because payroll will be covered by PPP forgiveness eventually? Project owner will want windfall to flow up. For time and material. I mean, I think, I'm not really entirely sure what the question might be asking, but I mean, for any time and material charges during the PPP expense period, that labor is eligible to be part of the forgiveness. If you're asking, to how do you segregate that information in order to be able to get the forgiveness, it's best to keep track. What I've advised clients is to maybe create a separate general ledger trial balance account, and any expenses for payroll that they were going to pay to the employees, put that into that account. And also each week when you get your payroll reports, save that information and store it separately in a file, so you'll be able to have a file that's going to show all of your PPP employees and all of the expenses that you've used for that forgiveness amount. Did you, Alex, any other questions?
There's one more question. As to PPP loan taxability, if the PPP loan is forgiven and becomes an offset to expenses, are there other tax consequences other than the reduction of the expenses?
No, that would be the most significant tax consequence, because you won't be able to take that deduction as you normally would have on your tax return. And so therefore you'd be able to, you'd have to add all of that money that you've used your forgiveness for back to your taxable income. Any others?
All right. No other questions have come in.
And of course, if anyone has any questions after the fact and be able to review the material once again, feel free to shoot any of us an email and we'll be more than happy to answer those questions for you. And so with that, I'd like to thank everyone for attending the webinar, especially Emmanuel and David for helping us put together this presentation. And if anyone has questions, again, reach out to any of us. Thank you and have a great day.
Thanks.
Thank you.